It is my view that list of adult choices includes deciding whether or not to alter one's biological sex. Making permanent and irreversible decisions regarding one's biological sex while still a youth can severely limit that child's choices in the future.
Adam Soos here for Rebel News. It would seem the government of Alberta isn't only standing shoulder to shoulder with other provinces on the federal stage in opposition to the carbon tax, but now also in the courts of law, as Alberta is set to intervene on a case in Saskatchewan in defense of parental rights. In August 2023, the University of Regina Pride Centre for Sexuality and Gender Diversity, henceforth known as UR Pride, filed a lawsuit claiming that the bill would violate children's right to life, liberty, and happiness. And on September 28th, Saskatchewan's Court of King's Bench granted them an injunction to suspend Bill 137 until hearings were conducted. Now, the government of Saskatchewan responded by passing Bill 137 shortly thereafter by invoking the notwithstanding clause to effectively disregard the court's ruling for 5 years. Despite the use of the notwithstanding clause on January 10th and 11th, the court heard arguments from both the government and UR Pride, and on February 16th, Justice Michael McGaugh, excuse my pronunciation there if it's incorrect, ruled that UR Pride's constitutional challenge would be allowed. The Government of Alberta, which recently brought forth its own parental rights policies, plans to file an application to bar the Saskatchewan Court of King's Bench from reviewing the constitutionality of that province, Saskatchewan's Bill 137, the Parents' Bill of Rights.
We do need to have an evidence-based approach, and that's the reason why I've been watching quite closely the CAS report. And there's just some surprising revelations that came out of that. I'll just tell you a few of the things that she discovered. The report, there are conflicting views about the clinical approach, with expectations of care times being far from usual practice. It's made some clinicians fearful of working in gender questioning young people, despite their presentation being similar to many children and young people presenting to other services. The rationale for early puberty suppression remains unclear, with weak evidence regarding the impact on gender dysphoria, mental or psychosocial health. The effect on cognitive and psychosocial development remains unknown. The use of masculinizing and feminizing hormones in those under the age of 18 also presents many unknowns, despite their longstanding use in the adult transgender population. I think this is not the approach we're taking right now is not a science-based approach.
Alberta and Saskatchewan's Justice Ministers, Mickey Amery and Bronwyn Eyre, respectively, issued a joint statement affirming that both provinces have a commitment to affirming that the key figures in children's lives are their parents, adding that notifying parents and requiring their consent before a child's name or pronouns can be changed in schools and before classroom discussions about gender identity and other sensitive subjects occur ensures that the parent-child relationship is respected and paramount. In addition to expressing concern about the potential undermining of parental rights that may occur should the UR Pride challenge be allowed to proceed, the joint statement also expressed concern about the court's apparent flippancy, my words, not theirs, towards their invocation of the notwithstanding clause and considerations brought forth from the government that per the rule of the law, given that notwithstanding clause, any rulings the court finds would likely be rendered moot. Now, their statement reads, this case has the potential to impact not only parental rights across Canada, but also the application of Parliamentary Supremacy Clause, which has been an integral piece of the Canadian Charter of Rights and Freedoms and of the Constitution in Canada since 1982. Eyre went on to add that this is really an issue of parliamentary sovereignty. There's very important constitutional issue at play here about whether the notwithstanding clause is the final word.
With respect to the notwithstanding clause, it was part of those very charter discussions advocated on by the premiers at the time of Saskatchewan and Alberta, because there was, as those rights that were included under the charter were being discussed, there was other rights that were identified as well that were not included under the charter, and it was also identified that at some point in the future there could be the collision of these charter protected rights and other rights that are important to Saskatchewan residents and to Canadian residents as well, and when those rights collide, the notwithstanding clause was provided to ensure that the elected government of the day would be able to make the decision on as to which of those rights would be in effect for the people that they ultimately represent. And in this case, that's the rights of a parent to ensure they're involved in their children's decision.
It will come as no surprise if your principal concern here, as my principal concern is whether or not the significant progress made by provinces like Alberta, like Saskatchewan, Saskatchewan and even some other provinces that are starting to put parental rights at the front, given the clear attack that has occurred from progressive activists seeking to remove parents from the equation, especially around conversations related to sexual or gender-based material. So that is absolutely a critical portion of this, and it is great to see provinces taking a stand of solidarity to affirm parental rights. But the secondary concern here, as the statements mention, is whether the sort of due process of this notwithstanding clause being invoked, affirming the supremacy of these political elected bodies to affirm the will of their people, will actually be respected, or if the at times ideological courts will be able to sort of weigh in and shift things, and in potentially worst case scenario attempt to undermine the work that has been accomplished by these governments.
Parents are the primary caregivers and educators. Successful society without strong and nurturing families. And regardless of how often the extreme left undermines the role of parents, I want you to know that parental rights and choice in your child's education is and will continue to be a fundamental core principle of this party and this government, and we will never apologize for it.
So there are two very interesting conversations to follow moving forward, and you can of course trust Rebel News to bring you updates both on what sort of determinations are made on the parental rights front, but also if the courts to see if the courts are indeed respectful of the invocation of the notwithstanding clause. An interesting story indeed, and one that we will continue to follow. As always, I want to thank you all so much for tuning in. For Rebel News, I'm Adam Soos. Hey, if you agree that governments need to continue standing up to woke progressive activists who are pushing their agendas, often completely age-inappropriate agendas, into classrooms and into places that they don't belong, sign our petition at stopclassroomgrooming.com.